In a short 2-week session in the fall, legislators passed a bill that proposes 115 pages of rewrites to the state constitution within Article 7, ranging from everything from a government growth limit to narrowing constitutional protections for church property to eliminating constitutional protections for veterans groups and a whole range of other things. Many, many, many things be changed. And so then that was put to the voters, and it's going to be put to the voters on March 29th. But there's some problems with it. The first is that the language that will be on the ballot is just one sentence long. It's just one sentence that sort of incorporates by reference this more than 100 pages of changes to the Constitution. But even that one sentence isn't truthful with voters. It doesn't tell voters the truth about changes to protections for church property, doesn't tell voters the truth about pay for teachers and a couple of other things. And so my clients filed a lawsuit. There are 2 teachers and a pastor who said, this isn't right. If we're going to change the Constitution, which we can do, right? The Constitution can be changed. We need to make sure we're doing it in a way that's truthful with voters and complies with the rules that have been set out for how we do this. We think that those rules have to be met. So
thank you, ladies and gentlemen, for joining us once again on the State of Freedom.
The State of Freedom is a listener-supported podcast. We're committed to pursuing the truth about policymaking, decisions, and situations in Louisiana and at the national level that stand to impact our freedoms.
Please become a monthly supporter of the State of Freedom at freedomstate.us as we continue to expand the voice of liberty across Louisiana and beyond.
Joining us today is returning guest William Most. He's the New Orleans attorney who brought the case against Secretary of State Nancy Landry yesterday on the proposed constitutional amendment number 2. He argued yesterday in court on that. He argued that case yesterday and won. So congratulations to you, William. This proposed amendment has become increasingly high profile in its controversy, and we will get a full readout here shortly on how the trial went. Before we do, would you just join me in reading the scripture of the day? It's 1 John chapter 3, verses 18 and 19. And it says, "Beloved children, our love can't be an abstract theory we only talk about, but a way of life demonstrated through our deeds. We know that the truth lives within us because we demonstrate love in action, which will reassure our hearts in his presence." And we can spot a hypocrite from a mile away. And, many people have left churches and even have left the faith because of hypocrisy that they've seen and experienced in the church or in lives of people who call themselves believers even outside of the church. But as Christians, we're called not only to love, but to demonstrate our love through actions. And because we are not perfect people, we all have moments and circumstances where we mess up and moments where we do things that genuinely do make us hypocrites. And humility is absolutely necessary. This is why humility is necessary, because what brings healing and resolution to those times when our actions don't line up with love and don't line up with who we are, it takes humility to admit that we're wrong. And it takes humility to ask for forgiveness, not just from God, which is, the cowardly way to do it, just ask God for forgiveness in secret. But we also have to ask the people that we've hurt. Repentance is a gift because it's the key to restoring us back to right alignment, both with God and with people. And the humility to ask for forgiveness is key to demonstrating true love in action, because true love seeks forgiveness and reconciliation.
Yeah. And you know what keeps us from asking for forgiveness or reconciliation with other people? It's pride.
It is.
People don't want to admit that they've made a mistake. People don't want to admit that perhaps they got it wrong. But it's important to be able to do that for personal growth and as we move on down the road of knowledge and personal self-development. I think your scripture today, in terms of seeking forgiveness or admitting a mistake, could very well apply here to the people who have been pushing and promoting Constitutional Amendment 2, because
Well played.
I suspect, Danielle and William, that a number of legislators, because of the extraordinarily narrow time constraints in which this was adopted in the legislature, may not have had time to read a 115-page bill, may not have fully understood the full implications of it. And so what do you do in a situation like that? Once you've committed to something, you either have the ability to admit, okay, we were wrong and we have an obligation to let the voters know that this is not right, or we double down and we continue forward. And way too many of them are doubling down for the wrong reasons. And that brings me to this point, William. First of all, as Danielle said pre-show, congratulations on your success yesterday in court. Judge Louise Hines refused to throw out your preliminary injunction, is allowing it to proceed to a full hearing. And one of the things that I noticed, and I want to get your thoughts and insights on this, is that it doesn't appear that the Attorney General is opposing your suit on grounds of merit. It looks like they are principally opposing it because they're saying it's too late to do anything because it's too close to the election. And for whatever reason, there are no grounds, procedural grounds to bring it. It's more procedurally barred. Did they address yesterday the merits, which really, in a nutshell, and this is probably an oversimplification, the fact that there are these substantive differences between what is actually represented on the ballot that voters will vote on and what's actually contained in this gargantuan 115-page amendment? Did they address that allegation at all yesterday?
Not much yesterday. And if you'll bear with me, thanks for having me on the show.
Sure.
Maybe I can give just a brief nutshell of how we got to where we are, and then we can talk about yesterday's court hearing because,
Perfect.
there's a process that led us to where we were yesterday. So, as both of you know, Danielle and Chris, what we're talking about here is Amendment 2, which is something that will be on the ballot potentially on March 29th for voters to vote on, that would propose us to make changes to the state's constitution, our foundational document. And this grows out of a series of efforts last year by some state officials to rewrite the state constitution. And one of those efforts was stopped by Republican legislators last fall. But then some state officials kept trying. And in a short 2-week session in the fall, legislators passed a bill that proposes 115 pages of rewrites to the state constitution within Article 7, ranging from everything from, the government growth limit to narrowing constitutional protections for church property, to eliminating constitutional protections for veterans groups, and a whole range of other things. Many, many, many things would be changed. And so then that was put to the voters. It's going to be put to the voters on March 29th. But there's some problems with it. The first is that the language that will be on the ballot is just one sentence long. It's just one sentence that sort of incorporates by reference this more than 100 pages of changes to the Constitution. But even that one sentence isn't truthful with voters. It doesn't tell voters the truth about changes to protections for church property, doesn't tell voters the truth about pay for teachers and a couple of other things. And so my clients filed a lawsuit. There are 2 teachers and a pastor who said, this isn't right. If we're going to change the Constitution, which we can do, right? The Constitution can be changed. We need to make sure we're doing it in a way that's truthful with voters and complies with the rules that have been set out for how we do this. We think those rules haven't been met. So the plaintiffs filed a lawsuit, and yesterday was a hearing that was scheduled to be about 2 things. Number one, about requests by the Attorney General and the Secretary of State to throw this case out entirely. That was issue number 1. And then issue number 2 was, should the court issue a preliminary injunction, which is an order saying, hey, let's hit the pause button. Let's not move forward with these changes to the Constitution until we can figure out whether voters have been told the truth and the law has been complied with. And so what happened yesterday is the court took up the issue of whether the case should be thrown out. She said no. And then she paused things for just about a week and a half so that the Secretary of State can appeal if she wishes to, go up to the next higher court. And then we're planning to reconvene next Friday to potentially take up the issue of whether to issue an order hitting the pause button.
William, so what Judge Hines did yesterday was grant a full hearing on the preliminary injunction. Is that correct? She granted a hearing on the injunction.
Yeah, that was originally scheduled for yesterday, and then she took up the question of whether to throw out the lawsuit and then rescheduled the preliminary injunction
Okay.
question for next Friday.
So you didn't have a full hearing on the preliminary injunction yesterday.
Correct.
Okay. Now, if she she has not yet made a decision about whether or not she is going to grant a full hearing on the merits. Is that right? Because she's pausing it to allow the appeal this to the Louisiana Supreme Court.
Yeah, so she basically gave about a week and a half to the Secretary of State to go to a higher court, whether it's the Court of Appeal or the Louisiana Supreme Court, and see if they agree or disagree with her decision not to throw this case out. Because she
Okay.
recognized, I think pretty correctly, that we have laws for a reason, right? The Attorney General and the Secretary of State were trying to argue that, yeah, the election code says that ballot language can't be unbiased, but no one can sue to enforce that. That was their argument. And the judge pointed out, what are the point of laws if they don't have effect? And so she refused to adopt the arguments to throw this case out.
Well, that's great. And, even if they did this, even if everything that was in this constitutional amendment number 2 was something that we as a people all agreed was good, there's this concept of doing the right thing the wrong way. And there is a method laid out in the Constitution for how you are to appropriately bring forward an amendment. And this does not even meet that test, if I understand correctly, William.
That's exactly right. So the Louisiana Constitution has its own rules for how you change the Constitution, right? Because the Constitution is a document that changes over time. Our current Constitution was put together in the 1970s in a convention by delegates from across the state, spanning all sorts of different groups. And they put together a Constitution that contained within it a process for amendment. And what that process for amendment says, if you are going to amend less than an entire article, like Amendment 2, you have to do one object at a time. So you need to present the voters one change at a time so they can say, yes, I like that, or no, I don't like that. What you can't do is package together 40, 50, 60 different things where, a voter might say, well, I like 1, 2, and 3, but I don't like 4, 5, and 6. You can't stuff things together like that because that doesn't really give voters the choice about which changes to their constitution they want to make and which they don't. And
because you could have, William, a situation where a voter fully agrees with one of the provisions in a proposed constitutional amendment, but adamantly opposes another. So what is a voter supposed to do? William, if the only thing that this proposed constitutional amendment contained was a provision to alter the traditional tax exemption for religious organizations and gut the tax exemption for secular nonprofits. If that was the only proposal in the amendment, then this particular objection would be moot, right?
Right. If they were doing one thing at a time, the way the Constitution requires, we wouldn't have a quibble about this part, right?
As long as they said what it was, right, on the ballot.
Yeah. And
truthful voters doing one thing at a time, the way the rules require, then voters get to choose, right? We're a democracy. But I think the problem here is you're exactly right, Chris, which is there's probably voters in Louisiana who like certain parts of it. Like they hear, this is going to reduce some taxes, right? And they like that. But they don't like, this is going to narrow constitutional protections for my church. And so what are they supposed to do? They're caught in a dilemma where they like some things, they don't like other things. And the rules of the Constitution say you shouldn't be forced to swallow something you don't like in your Constitution just to get something else. We're
Fair
supposed
enough.
to do it a la carte for this kind of change.
The secret to losing weight 2 times faster has gone viral. See the transformations hundreds of thousands of people are experiencing around the world with the Slender Eyes drops. These homeopathic drops are proven to control appetite, support thyroid function, help balance the body's pH, improve energy, boost mood, and increase metabolic rate. I've heard firsthand testimonials from droppers in their 20s to droppers in their 80s who say that the Slender Eyes drops have completely revolutionized their lives. Try the drops today to see the results for yourself. To learn more about the Slender Eyes drops or other incredible natural wellness and lifestyle products, email me at info@freedomstate.us and put drops in the subject line, or visit the Shop Our Partners page at freedomstate.us. We also have links to those in the show notes. Thank you for supporting the state of freedom.
Yeah, in other words, voters should not be forced in a catch-22 situation when they're going to vote. And I think that is I wrote an article in the Hayride in response to another article in the Hayride in which he called this particular objection that we're talking about now a technical objection. And I'm thinking to myself, how can this possibly be interpreted as a technical objection when a voter is in a voting booth and they're having to sit there and say, I want to, assuming this really did provide a guaranteed teacher pay raise, which it doesn't, but just for purposes of argument, assuming the proposed amendment did provide a permanent teacher pay raise, but then that they want to vote for. But then on the other end over here, they're stripping out of the Constitution exemptions for tax exemptions for nonprofits. That's exactly the kind of catch-22 you're talking about.
Yeah, that's right. And look, I don't think complying with the Constitution is ever a technicality, right? These are the basic rules that set up our democracy. They're not technicalities. I think that's a word people use when they don't like the rules, right?
Yeah.
So these have a lot of substance to them. We don't have a functional democracy if people are being asked to vote on things in a way that breaks the rules and isn't truthful with voters.
Yes. And in the article that I wrote, William, basically, to me, it all really comes down to one core principle. And that is that in a constitutional democracy, voters have a right to know that what they're reading on ballot language, which is all many voters will look at. I don't know of one voter who's going back and reading this 115-page bill. They rely on the ballot language. And we have a core right to know that what we're reading and upon which we base our vote when we go into the voting booth is accurate, is truthful, is factual, is objective. If we don't have that, if we set this precedent whereby proponents of these proposed constitutional amendments can contradict or misinterpret or misrepresent in ballot language what a bill actually says, to me, that is an extraordinarily dangerous precedent going forward, because we can't know 100% for sure whether or not what we think we're voting on is really what we're voting on.
Yeah, and that's why it was pretty disturbing to hear representatives of the Attorney General and the Secretary of State argue that the Constitution says that, yeah, the election code says that, but you can't enforce those rules, right? Because rules, if you can't enforce them, are just words on a piece of paper.
Yeah.
Yeah, and what
go ahead,
kind of
Daniel.
constitutionality should we believe is in this amendment? Like, what faith does it give the people in the constitutionality of the amendment if the AG didn't even argue that the amendment was proposed in accordance with the Constitution? That wasn't even part of the argument, right?
Yeah, it didn't come up in court yesterday. The Attorney General filed a very short document that sort of alluded to the fact that they think it's constitutional, but they didn't provide a lot in the way of argument. Primarily, the focus has been trying to throw this case out before we get to the question of whether Amendment 2 complies with the law or not. Because I think in part, it's really hard to argue that Amendment 2 complies with the law. It's really hard to do that.
Yeah. What is the response, William, to their argument, sort of the logistical argument, that we are too close? Well, actually, I think that you conceded the argument yesterday that because we are so close to an election, that these amendments will actually go on the ballot. but the determination will subsequently be made about whether or not their votes, anybody who votes for it, are valid. Is that where we are? In other words, there'll be a determination about what effect, assuming it passes, what effect in law the successful passage of the amendment may or may not have.
Yeah, that's basically right. So we're so close to the election that it's probably too late to pull stuff actually off the ballots because some mail-in votes have already been cast. But, the point of this lawsuit is not stopping an election. It's stopping the illegal changes to the Constitution, right? And so there's still plenty of time to do that. So things may appear on the ballot on March 29th, but you're exactly right. The real question is, will it take effect? So there will be questions of, okay, if people vote, will those votes be counted before we figure out whether the rules have been complied with? Will this take effect? Because there's plenty of time before or after an election to make sure that the rules are complied with. And it was pretty wild in court yesterday because the Attorney General and Secretary of State weren't just arguing that we were too late. They were also arguing that we were too early. So they literally were both saying, at one point they said, no, this is too late. Ballots have already gone out. And then they turn around and then without even seeming to realize they were contradicting themselves, they said also they filed this too early. They have to wait until after the election. And of course, something can't be both too early and too late at the same time. Unless, I guess, maybe there's a sweet spot in the middle.
It's because they want to be able to, after the fact, say that, oh, it's too late. They want to force the issue any way possible. That's so insane. William, I want to ask you to take off your attorney hat for a second, put on your Louisiana citizen hat. So one of the objections we're hearing from legislators about this in hindsight or justifications rather, is, we're just going to fix the problems after it passes. So go ahead and vote for it. Don't worry about it. Trust us. We're going to take care of it when we get into session in a few weeks. What's your response to that?
I mean, that's pretty scary to me. The idea that we would pass a broken, bad constitution and have the Louisiana, the core document of our state be broken and bad, and then we'll fix it later. That's pretty worrisome to me, especially because there's no guarantee they'll fix it later, right? I would rather not have to trust someone to fix a broken, bad constitution. My preference would be don't have a broken, bad, illegal constitutional amendment.
Yeah.
Yeah.
Particularly,
if we couldn't trust you to put it in right, then how can we trust you to take it out right?
Right.
Exactly. And as a constitutional conservative, to that point, I pointed out that the same legislature that is asking us to trust them to go back and fix this is the same legislature. And we have some good conservative leaders in the legislature, okay, some very good ones who fight very, very hard. But this is the same legislature who's asking us to go back and trust them to fix this is the same legislature that killed a bill in committee that would have prohibited private corporations from acquiring access to private property against the property owner's will in order to inject these, to engage in these carbon capture sequestration projects and bury pipelines under people's property. Regardless of how you feel about carbon capture sequestration, climate change, and all of that, that is not really the point I'm making here. The point I'm making is whether or not the core constitutional right of property, to own property and to have autonomy over your own property, is trumps, companies' effort to acquire your property to go do these projects. That's number one. And this is a conservative Republican legislature. The same legislature that did a number of other things that really undercut core constitutional principles that conservatives believe in. So again, I'm a little reticent and a little skeptical to take a legislator's word at face value. We know it's messed up now. We know we didn't do this the right way, but don't worry, we're going to go back and fix it. So I agree with you 100% on that. Let's get it right now.
Yeah, I mean, if someone said, hey, I'm going to take your right to free speech out of the Constitution, don't worry, I'll put it back later. Would you take that deal? I would not.
And I don't think that most citizens, based upon sort of the skeptical view that we have of our government in general, takes that view. I think it's but one thing I do find interesting based on what Danielle said is that there are legislators who are saying now, conceding that this is not right, that we didn't do this the right way. And I think that in and of itself is noteworthy.
Yeah, I mean, I think that's right. Like, I think if you asked the legislators who voted for the bill that became Amendment 2, if you set them all in a room and said, okay, raise your hand if you knew that this was going to narrow constitutional protections for religious group property, I don't think any hands would go up, right? If you ask them, did you know that this is going to eliminate constitutional protection for every VFW hall in Louisiana? I don't think any hands would. I think many legislators legitimately did not know what was in this 115 pages of changes, because there's a lot of stuff in there. You really have to dig into the fine print to get it. Like, for example, this could allow taxes to go up on takeout food. You know, maybe that's not the biggest deal in the world, but you have to really dig into the fine print to see it. And I'm not sure the legislators did.
Yeah.
So it's
Yeah,
concerning.
and even if it's not, it may be a very big issue for people who order takeout food 2 or 3 times a week. That could be a very significant issue. A legal question that I wanted to ask you about a little more specifically here, William, is that because I want to make sure I'm clear on this and the listeners are clear. Did the court yesterday grant a full hearing on the injunction, on your effort to remove this from the ballot?
I believe so. She had scheduled a hearing for yesterday on the motion for a preliminary injunction. And then she has scheduled or she said she's going to schedule another hearing next Friday. So I think basically yes.
Okay, all right. And if she grants the preliminary injunction, at that point, do you go forward with a full trial on the merits, or is the preliminary injunction, if she grants it, is at the end of the line, the end of the case?
Yeah. So great question. So a preliminary injunction is just hitting the pause button while the case goes forward, right? Because there's all sorts of kinds of cases where, you know, any of your listeners who have any, you know, involvement in lawsuits know they can take a long time, right? Often so long that things change. And so a preliminary injunction is a tool for let's hit the pause button until this case can come to its full, you know, fruition, right?
Yeah.
So a preliminary injunction here would not be saying Amendment 2 is definitely unconstitutional. It would be saying, hey, let's not make any hasty changes to our Constitution until we can have a trial and figure out whether the law was complied with, whether voters were told the truth. So
Yeah.
it wouldn't finally resolve anything. The case wouldn't be over. It would just say, let's not make any changes. Let's maintain the status quo until we can take all the appropriate steps we need to make sure whether the law was complied with.
Yeah. And if she grants the preliminary injunction, if she grants it, isn't the standard in Louisiana, William, that in order for a judge to grant a preliminary injunction to allow you to go forward on the full merits of the case, isn't the standard that the judge, in order to do that, has to conclude that you are likely to prevail on the full merits in a trial?
That's right. So if a judge looks at something and says, oh no, this is a dead bang loser, they're not going to grant a preliminary injunction, right? Because it doesn't make sense to hit the pause button if the judge can tell this is a loser of a case.
Yeah.
But if the court says, you know, look, there's some good arguments here, right? This is looking pretty concerning. I don't think we should maintain the status quo until we can figure this out with some finality. That's when a preliminary injunction kicks in.
Yeah.
Yeah. So just to be clear, if the preliminary injunction is granted, that would mean that whatever happens on Amendment 2 this election would not count. They could potentially bring Amendment 2 in a future election if the court rules in their favor when you have a full hearing. Is that what I'm hearing?
Yeah, so I think it's a little unclear what the judge will say exactly if she issues a preliminary injunction. You know, she could tell the Secretary of State, okay, you know, people are going to go to the ballot box, but, you know, just don't count those votes. Keep them somewhere. Don't count and report the votes till we can figure out whether this should have been on the ballot in the first place, right? Or she could say, you know, you can count the votes, but we're not going to let Amendment 2 take effect until we have, you know, further proceedings.
Yeah.
Well, but you're exactly right. I mean, if people wanted to fix this and do it right, they certainly could, right? There is a process for changing the Constitution. We're not disputing that. We just want to make sure they do it right. So if they go back and do it right, more power to them.
Yeah.
Isn't that interesting? They could go ahead and just not count the votes, quote unquote, and bring them out later. Like, for instance, if they decide in court that you lost, would they just unearth those votes and say, oh, look at that, Amendment 2 passed or failed? That's insane, because it is the Secretary of State who's counting the votes.
Yeah, I mean, it's the Secretary of State's job to count and report the votes. So I think, it's a question of,
Wow.
we're trying to hit the pause button on this, right? And so what thing do we actually pause? And I think there's a range of ways to accomplish it.
Yeah.
That's so interesting.
It is interesting. So the issue now, again, is not whether or not this will go on the ballot as written. The issue is whether or not these votes will ultimately be counted and therefore made effective, assuming the amendment passes. What do you recommend, William, at this point? I'm assuming that your recommendation is the same, as long as there is even a slim possibility that these proposed amendments, if passed as written, could take effect. Then your recommendation is obviously for people to vote against it.
Yeah, I mean, look, I'm voting no, right? I'm voting no on all the amendments on the March 29th ballot, because I think there's some serious problems with all of them. But, for other people, I think, if you got the time, figure out what Amendment 2 would do to you and your community, right? So figure out whether Amendment 2 would narrow constitutional protections for your church or nonprofits you care about, or the Salvation Army, or, Catholic charities. Figure out whether Amendment 2 would limit local control over some taxes, right? Sales taxes. See if these are things that you want. See if Amendment 2 would destroy constitutionally protected funds for education and infant mortality protection programs. These are all things that Amendment 2 does. And I think people should learn about it. If they're thinking about voting yes, I would recommend learning more about what it's going to do to you and your community before you go into that ballot box.
Yeah. One of the issues that was not, I don't believe, explicitly brought up in the lawsuit, but we discussed it briefly on your last appearance on our show, is that the standard deduction, Louisiana taxpayer is constitutionally allowed to deduct from his state taxes any amounts that were paid in federal taxes. It's a standard state tax deduction. That is not included on the ballot language, and it clearly is being removed. Is that a significant issue that voters also need to be looking at?
Yeah, I think that's something to look into. I'm less clear on the mechanics of that, but I think, look, these are good questions, which are, there's changes spanning more than 100 pages, right? And there's a lot of stuff in there that people don't know about that's not in that one sentence ballot language. So,
yeah.
It's hard to figure. Look, I'm a lawyer. I've got a team here, and we're still learning things about what Amendment 2 would do if passed, because there's so much packed in there, which is the whole point. You're not supposed to just pack in a bunch of things that people can't figure out and then expect them to vote on it. So,
right.
Yeah, these are all concerns that people have. And faith leaders across the state, I think, are waking up and realizing that we got a problem here. And so you've seen in the news maybe that faith leaders are starting to say, wait a second, you're proposing to narrow our protections for our church property across the state? That's a real concern. So people are starting to see that there's stuff in Amendment 2 that causes them a lot of worry.
Yeah.
I think so.
Again, before we close out here, William, I really do believe, to reiterate, that the whole thing comes down to, I'm not concerned about how people vote. We have a core constitutional right to make a vote of our choice based on our conscience, based on information that we have. Whether you vote for it, whether you vote against it, that is of far less concern to me than making sure that the information that you're reviewing, upon which you base your vote and that informs your vote, is truthful and accurate and complete and understandable. And so whether you're a Democrat or Republican, whether you're going to vote for or against, that's a right that we all have a vested interest in knowing that we're getting accurate information. And that really seems to be sort of the substantive core of your argument as well.
That's right. Look, I mean, we're a democracy. Sometimes your side wins, sometimes it doesn't. But that's our protection against tyranny, right? To have to have the people get to make choices. But you don't have a level playing field if the ballot language itself is slanted, right? If the ballot language itself is slanted and untruthful and only says the nice things and not the not nice things, then you're not giving people a real choice. You're not telling them the truth about what you're asking them to vote on. So we need to have a level playing field. We need to have a functional democracy. And if we have those things, then people, then let's keep going. But we can't let state officials put slanted, untruthful things on our ballot and then, and ask people to vote anyway.
Yeah. It's really about the principle of this even more than whether or not Constitutional Amendment 2 passes or fails. It's the principle that is at work here. And you're right. I mean, this is the kind of thing that would create a precedent whereby the government now believes that they can misrepresent ballot language, put things on there that aren't true, mislead voters with legal impunity. That is why this case is so important to me. And, I applaud you're bringing it again. Congratulations on your victory yesterday. The case is clearly has more than just marginal merit. It is a compelling case that directly affects the extent to which Louisiana voters can meaningfully participate in the democratic process. And that's what you're bringing out. And I think that is the great value of your suit.
Well, protecting democracy is a team sport, and we're all part of it, right? The work that Danielle, you and Chris are doing to get the word out to people is critical. We're doing our part. Other people are doing their part. Our clients have stood up and said, this is wrong. So, we're all on team democracy, I think. And I appreciate everything y'all have done to inform people about the situation.
We've all had instances crop up where we could use the advice or skills of a trusted attorney. Whether you're looking at the implications of new laws for your business, signing a contract or a lease, looking to write a will or establish a trust, or even resolve a dispute with your credit card company, LegalShield has got you covered. For over 50 years, LegalShield has made it affordable and easy to access a dedicated lawyer. With the app, LegalShield is like having a lawyer in your back pocket. For covered emergencies, LegalShield is here for you 24/7, plans to fit any stage of life. The State of Freedom is proud to be teamed up with LegalShield as clients and affiliates. To learn more or to sign up, visit the Shop Our Partners page on freedomstate.us or check out the link in the show notes. Thank you for supporting the State of Freedom.
Thank you. Last point I wanted to make here, and I just find this very interesting, that it's been suggested, William, that the opposition to Constitutional Amendment 2 is being fueled in substantial part by leftist agitators, by people who are simply opposed to a quote unquote conservative tax reform agenda. And that couldn't be farther from the truth. I mean, I am a lifelong constitutional pro-life conservative, and you perhaps are not. Perhaps you and I have significant differences on policy issues and on in issues that regarding the scope and reach of government and many other issues. But we agree on this because it is a matter of fundamental transparency. And I think that there is a growing coalition of both moderates, progressives, and even liberals with constitutional conservatives on this issue, because we all recognize the critical importance of a government that is fully transparent with us.
Yeah, that's right. That's why it's been so inspirational to see this, because you see people from across the state of Louisiana, from across the political spectrum, from all walks of life, standing up, saying this is wrong. This is not okay. You see this in the newspaper. You see people from the right and from the left both saying we cannot have an untruthful ballot measure like this. So,
Yeah.
It's not about any one person's politics. This is about the basic rules of a democracy. And a lot of people are on board.
Yeah. What's next procedurally in the case before we let you go?
Yeah. So likely over the next week and a half, there will be a request for an appellate court, whether it's the Court of Appeal or State Supreme Court, to weigh in on the judge's decision not to throw out this case. And then unless something happens, we are scheduled for a hearing on Friday the 12th to resume with the case, presumably take up the question of a preliminary injunction and keep moving forward.
Great. Well, keep us posted on how it develops.
Yeah. William Most, attorney for the two teachers and the pastor trying to nullify Constitutional Amendment 2. Thank you so much for joining us. Your insights are always valuable, William.
Thanks, Chris. Thanks, Danielle.
Thank you. Have a great day.
Thanks for joining us today on the State of Freedom. Be sure and check out the show notes for this episode. You can always go there and find the calls to action and resources mentioned in the show, and you can find out more information about our advertisers there as well. If you want to learn more about us or support our work, visit freedomstate.us. To get involved with Louisiana Citizen Advocacy Group, visit lacag.org. We'll see you next time. God bless.